Last year also, we had a very highly successful landing visit to the United Kingdom when I visited your lordship, and we had an opportunity to interact with other various judicial officers and institutions. And from this visit, we learned a lot from your experience and expertise in dealing with various issues that affect the administration of justice. We learned a lot about case management, judicial independence, judicial ethics, alternative dispute resolution, and generally access to justice. I've just come from a global meeting held in Vienna where we were discussing criminal law reforms to make it more humane and to make it more accessible to our people. And we were looking at the hindrances that make us not deliver justice expeditiously, especially in the area of criminal justice. We have also, since we've been interacting with you, embraced technology and innovation to enhance service delivery and efficiency in our courts. This visit, therefore, is very enriching and inspiring for us, and we have since implemented some of the lessons that we learned and customized them within our own context. Indeed, our visit to the UK was an affirmation to the spirit of mutual growth and learning, and today we are keen to extend the same hospitality to you, my Lord Chief Justice. Therefore, your presence here is not just a symbol of our country's friendship, but also a restatement of the mutual respect and cooperation of both our judicial systems. The Kenyan judiciary remains steadfast in our pursuit of excellence in service delivery and justice for all. We are keen to deepen our partnership with other judiciaries around the world, especially those that share the common law heritage and values. We are convinced that it is through these collaborations that we can achieve the global justice, that we can share insights and broaden our perspectives and work towards the common objectives. We believe that justice knows no borders, and the more we learn from each other, the more our societies and our people will benefit. Moreover, we believe the judicial collaboration is essential for promoting the rule of law, human rights and democracy, and also development. We also recognize that we face common challenges and opportunities in this era of globalization and digitization, such as cybercrime, terrorism, climate change, migration, and pandemics. And may I add also, the sexual and gender-based violence. It's a global pandemic that we are all seeking for common solutions. Indeed, in this era of global interdependence, our institutions must work and come together in pursuit of the common good. Therefore, we need to work together to find solutions that are responsive to our changing realities. Once again, my Lord Chief Justice, I thank you for your visit, and I'm certain that our judges, our registrars, judicial officers, and legal professions will benefit from your insights and perspectives on the various topics that you will address.
Great privilege for me to be here in Nairobi and to have been asked to speak to you today about fostering inter-judiciary dialogues for the future of judiciaries in a globalized world. It was a real pleasure for me a few years ago to meet Chief Justice Miraga on more than one occasion before he retired. And Chief Justice Koome and I now feel like old friends. And there have been many opportunities for me to meet Kenyan judges and lawyers both in London and at several conferences around the world. I was determined to come to Nairobi in my term as Lord Chief Justice. And the reason I have been determined to come to Nairobi is to demonstrate my admiration for the judiciary of Kenya and for the legal profession of Kenya. The subject of judicial dialogue is important. We learn so much from talking to each other to understand our common problems, the different challenges we all face, and how we can borrow from one another to solve problems. Friendly relations between judiciaries also contribute to international harmony more generally. We are all steeped in constitutional theory and know well that there are three branches of government: the legislature, the executive, and the judiciary. But it's very well established that the judiciary is the weakest branch of government. Alexander Hamilton, the United States Vice President, now made more famous by the musical, writing in the Federalist Papers in 1788, attributed this weakness to the absence of the purse, which of course belongs to the legislature, but whose contents are allocated, at least in the United Kingdom, by the executive, and the absence of the sword, which belongs to the executive. The fact that the judicial branch is the weakest branch does not mean that it is the least important of the branches of government. The judiciary is of equal importance to both the legislature and the executive. All democracies depend on the rule of law, and an independent judiciary is the bedrock on which the rule of law is built. Given, however, the systemic weakness affecting all judiciaries around the world, the importance of inter-judiciary dialogues becomes all the more clear. That's because there are common issues, problems, and challenges which confront judiciaries. Experience shows that some judiciaries will adapt better than others to different problems, while at the same time being weaker in response to other problems. The ability to exchange ideas, failed attempts at solutions, and working solutions to shared problems is vital. Chapter 10 of the Constitution of Kenya, and Article 160 in particular, makes provision for an independent judiciary appointed by a Judicial Services Commission. The common law provides for an independent judiciary, and Section 3 of the Constitutional Reform Act of 2005 guarantees continued judicial independence. And it was that act that established an independent Judicial Appointments Commission in England and Wales. A practical illustration of the shared values appears from the oaths required of a judge on appointment, a material part of ours. And I will do right to all manner of people after the laws and usages of this realm, without fear or favour, affection or ill will. And that's reflected in yours: to impartially do justice in accordance with this Constitution as by law established, and the laws and customs of the Republic, without any fear, favour, bias, affection, ill will, prejudice, or any political, religious, or other influence. Now, Kenya and England and Wales are both common law and Commonwealth jurisdictions. Many of the cases that come before the courts would be decided in much the same way in Mombasa as in Birmingham, in Nairobi as in London. As Commonwealth jurisdictions, we share democratic values and adherence to the rule of law required of its members. It's naive to suppose that all governments adhere precisely to the high ideals of the Commonwealth, or even that every judiciary is operating as it should. But the basic principle of democracy governed by the rule of law is the common goal. And the same may be said of many other countries around the world with whose judiciaries we in England and Wales have close connections. Thus, a dialogue between two such jurisdictions sounds both possible and sensible. But what shall we talk about? Well, shared problems. It's disappointing to move from looking at constitutional provisions to discuss problems. But it is important to realize how many problems are shared. Now, in her illuminating opening address this afternoon, the Chief Justice referred to a series of issues in which there's been dialogue between the judiciary in England and Wales and the judiciary in Kenya. And each one of those represents a problem. And the last she mentioned, gender violence and sexual violence, is undoubtedly a common problem faced by almost every jurisdiction in the world. But you may be pleased to know that in the time I have available to me, I won't speak about all of the problems which confront us and on which we might talk. I would like to highlight two in particular, namely the funding of judiciaries and challenges to our institutional independence. As to funding, it's now becoming more accepted that the executive has a constitutional obligation to provide adequate funding to the judiciary. Principle 7 of the United Nations Basic Principles of the Judiciary of 1985 provides, "It is the duty of each member state to provide adequate resources to enable the judiciary to properly perform its functions." Principle 4 of the Latimer House Guidelines of 2003 provides, "Adequate resources should be provided for the judicial system to operate effectively without any undue constraints which may hamper the independence sought." It's obvious, however, that with very few notable exceptions, Singapore is always mentioned in this context, the judiciaries around the world are rarely provided with resources which enable the judicial system to operate effectively. In England and Wales, as is apparent from evidence I've given to the Justice Select Committee, a committee of the House of Commons, we have struggled on occasions to secure the resources necessary to do all the work we would like to do in our Crown Court, our criminal jury trial court. Resources were constrained to reduce the throughput of cases and to maintain the outstanding caseload at a higher level than was necessary. This was done to save money, not only in supporting the courts, but also in the prisons, on legal aid, and so on. I've also spoken publicly, indeed repeatedly, of the woeful state of many of our court buildings, where maintenance has been neglected for years. Vast sums are now needed to make good the damage done by underfunding. Indeed, I'm in discussion with the government as I speak to seek funds even to deal adequately with urgent repairs. Our system has been run on a shoestring for as long as anyone can remember. The international instruments talk of adequate funding. That, you may think, is a slippery word. In England and Wales, the duty upon the government is to provide sufficient funds for an efficient and effective court service. Those two are vague, elastic words with very fuzzy edges. I know from discussions that I've had with judges from Kenya at other international events that Kenya has had its own problems with funding. But I will leave you, if I may, to articulate them if you wish.